Good afternoon. Welcome to the Appellate Division. This is our special election calendar today. Although there are 4 cases on the calendar, the 2 cases are each going to be heard and argued together. So the first 2 cases are Kane versus New York City Board of Elections and Kane versus Haniff. Appellant? How much time are you requesting? And yeah, the two appeals will be heard together, so you'll be arguing both together. Okay, that's not even allowed under our rules, but okay. Respondent, Hanif? Okay, and Board of Elections? Okay. So it will be 5, you'll get 5 minutes, and then you'll get a minute for rebuttal, and the 2 respondents will get 5 minutes each. No, that's not how we do it. You'll have 5 minutes and a minute for rebuttal. Thank you. The next 2 cases are Stein versus Eisner and Eisner versus Stein. Those will also be argued together. And obviously, those are the identical issues in both of them. Appellant?
Stanley Stein for Stein as appellant and respondent in the combined cases. 10 minutes, Your Honor, and I would like 8 and 2 if that's possible.
Respondent?
And I'm also appellant, co-counsel.
Okay.
6 seconds, Steve.
Okay, is there a respondent on this case? Well, the Board of Elections. Okay, so you would go second. So do you want rebuttal time since you also have an appeal? I would like that. Okay. So on that case, the appellant will get 5 and 2. The respondent, cross appellant, or the appellant will get 5 and 2, and the Board of Elections will get 5.
Thank you.
Okay, and the first case is Kane versus New York City Board of Elections and Kane versus Haniff.
Step up.
You should go up to the microphone.
Before I start, I wanted to say that I submitted a document last night at 2:30 a.m. It was the incorrect document. I resubmitted it with the description corrected. The clerk's
We
office,
received that.
yes, the clerk's office returned the corrected document. I spoke to the clerk and I told him, can I upload the correct document? And they refused to let me to do that.
I can't help you with that right now. You have to deal with that with the clerk's office. Okay? You ready to argue now?
1 second. Okay.
Okay.
Okay. So in the first case, Kane versus Board of Elections only, the Board of Elections included a party, Robert Morgan III et al. On his brief, who's not a party to the action. So I'm not sure you have jurisdiction over this person and this matter or their brief. Okay. The second brief, Mr. Bright served the documents on NICEF prior to Ms. Paulson being consenting to service, so you don't have jurisdiction over his brief either, okay? This issue, if you were to ignore these case laws, would be akin to the Supreme Court of the United States ruling on a constitutional issue and ignoring the amendments. This case law that has been utilized is very old, has wartime provisions, and it's been cited numerous times, and if you follow the trail of citations, it will lead you to King v. Cohen. And if you review this, you'll see it's no longer relevant, and the board should not be using this case law to dismiss anything. Neither of the court's orders address anything, any argument made by the petitioner. They clearly just restate the same case laws, also the respondents' briefs restate the same case law. They do not address any of the arguments made or why or why not they would be valid. Okay, so I ask this court to review the arguments presented. And the reason these documents were filed on the 24th is because I consulted with two attorneys, one who told me that I had 3 days to file after the determination, and one told me I had until the 24th, and I should wait until the 24th and sneak it in. You know, as a attorney, as he claims to be a qualified election attorney, he should have known that these case laws existed. So I'm not sure why he would advise me that. So I did do my due diligence to provide this document and prepare them. I think the court should review the case law and see if they're relevant and review each and one of my arguments instead of just, you know, as the Supreme Court did and the respondents did, just argue the same issues over again without stating if these case laws are even relevant anymore or if the recodified laws are still even relevant anymore.
So let me ask you, do you dispute that you didn't serve by the 24th? Are you saying you did serve by the 24th?
I'm not disputing that I served after the 24th. My reason for serving after the 24th is because the court signed the order late. As far as service being required within the 14-day period, I'm disputing that his argument is valid because if you look at the case law history and the election law itself, there is no mention of the word service or completed or anything. When this was decided in King v. Cohen in 1944, that, in my opinion, was an act of legislation and it's not a function of a judiciary. Okay, you can't interpret language that is not there. That's like me looking at the clouds and seeing a dog. Okay, likewise, we can't, this law has been recodified and updated, recent update being 2023. That has not been taken into account in these case laws. You know, out of curiosity, I decided, let me see where this leads me. And each one of these laws leads back to King v. Cohen, and I presented these case laws to the Supreme Court. Nothing regarding those arguments were stated in the order. Okay.
Anything else you want to add?
And also, none of the issues regarding to Ms. Haniff being qualified for a position. Ms. Haniff does not live in the location where she's required to be by the election law. She has conducted numerous issues of fraud, including having an attorney contact me and trying to manipulate me not to file objections against her. Okay.
Okay, you have a minute for rebuttal afterwards. Thank you.
Okay, thank you.
Good afternoon. I'm Daniel Bright. I represent the respondent candidate, Shahana Hanif. I'll just start out by pointing out that the Court of Appeals has reaffirmed the holding of King versus Cohen a bunch of
The date
times.
by which the order to show cause had to be served was April 24th?
The last day to serve was April 24th.
Was it actually brought to court on April 20? Was it actually brought to court on April 24th?
I believe a petition was filed on April 24th, and no attempt at service was made until at least April 26th, which is 2 days after the statute of
The
limitations.
order to show cause had to be signed, didn't it?
Yes,
So when was it signed?
I believe it was signed on the 26th.
But it was brought to court on the 24th?
Yeah,
So why is the petitioner penalized for the court's failure to sign it on the day it was presented?
well, because there's a long body of case law from the appellate divisions of this state Supreme Court and endorsed by the Court of Appeals, not just in the King decision, which I actually think predates the date that the United States got involved in World War II, but it's sort of beside the point because the Court of Appeals has reaffirmed that holding multiple times.
But you can't dispute that the actual statute doesn't mention the word service, right? Are you saying that commenced includes service based upon how the interpretation of the case law has interpreted it?
The word that's used in the statute is instituted, so it's not just commenced. And instituted has been interpreted uniformly by the courts to include service. And the Court of Appeals has held that service has to be completed, and that means actual delivery of the signed order to show cause and petition before the statute of limitations expires. And it doesn't just include the King case, it includes matter of Angletti versus Morreale, 25 New York 3rd, 794. It's a
If the-
2015 case.
Okay, if the order to show cause wasn't signed until the 26th, 2 days later, presumably if it was brought to court on the 24th and signed on the 24th, maybe service could have been effectuated that day. How is that the petitioner's fault?
Well, the petitioner is at fault the way any other litigant would be at fault in an election law case, and has been held to be at fault countless times by not knowing or not getting an order to show cause signed before the expiration of the statute of limitations. By bring everybody, I mean, people that, I know she's not a lawyer, but people that practice in this area know that you go to court and present an order to show cause to be signed several days at least before the statute of limitations expires, so that you
Counsel,
can get
when
it signed
were
and
her-
served on time.
When were her petitions deemed invalid? Or when?
Well, she's challenging my client's.
I'm sorry, right.
Okay.
When was that notice given about the petitions?
I don't know that there is a notice about the petition that my client filed. It was filed April 7th, was the last day a cover sheet was filed.
Oh, I think I'm talking about her petitions.
Oh, yeah, but I'm not involved in that case.
Oh, I'm sorry.
That's okay. And I want to mention a couple of other cases, though. Thompson versus New York State Board of Elections, 40 New York 2nd, 814, a 1976 case, and matter of Squitieri versus Power, Squitieri, 25 New York 2nd, 801, a 1969 case. These are other Court of Appeals cases that say service, meaning actual delivery of the papers, has to be completed within 14 days of the last day to file petitions. It's the rule. You have to follow the Court of Appeals. I think you would probably acknowledge, and every other appellate division has expressly and repeatedly applied that rule. I don't know that, I couldn't find a First Department decision that explicitly ruled on that question. There are Supreme Court trial level decisions that apply that rule within the First Department. I'd also add that the petitioner was never my client was never properly served. She was not served in compliance with the method of service directed by the order to show cause, and strict compliance with the method of service provided by the order of show cause is required. I can cite one case which I did cite, I believe.
Service was made by email, which was not authorized by the order to show cause. Is that what happened?
Well, no, it's not just that. Service was made by, allegedly, by leaving the papers with a person of suitable age of discretion at her residence, and also mailing it. Apparently regular mail. The affidavit of service doesn't say first class. The affidavit of service also doesn't say that it was in an envelope that was marked personal and confidential as required by CPLR Rule 308, I believe B or 2. And but also the order to show cause.
Time on rebuttal to address whatever else you need to address.
Oh, excuse
Your
me?
time's up.
Okay, I was going to say
Time
the
on
order to
rebuttal.
show cause requires overnight mail for as part of any service except personal delivery to the candidate. So there was no overnight mail.
You'll have time on rebuttal to finish
Okay.
this point now. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Susan Paulson on behalf of the Board of Elections. Your Honors, as was previously discussed, the election law requires that to institute a proceeding, it must be filed, as well as service must be completed in all necessary parties. And election
Let me
law,
ask you the same question. What happens when the order to show cause is just not signed by the judge and there's a delay as
Yes.
there was in
Well,
this
Your
case?
Honor,
Does that
I
have
mean-
any impact?
the plaintiff here proceeded essentially at her peril. The board invalidated the petition on April 14th, 10 days previously. She elected to wait until the last possible of the day on which she had to institute her proceeding, which involved both the filing and the service. Having done so, the court did not endorse the order to show cause until the 26th, and she didn't serve the board until the following date. This is not a situation in which the petition was not determined and there was not sufficient time. I mean, the statute allows that you must
So your
commence-
position is that the 24th is the law day, and you've got to do whatever you need to do to be sure that you get that order to show cause signed that day. And there's no inequity in that because you've got your decision on the 14th. Don't wait until the 24th in order to get the order to show cause signed.
That's exactly right, Your Honor. What the statute provides is that you must commence the proceeding within 14 days after the last day to file the petition, which here was April 10th, or within 3 business days after a determination of invalidity, which here was April 14th. So the statute allows a little bit of breathing room there, at least 3 days from the date of invalidity, because order to show cause may not be signed on that date. By waiting until the last possible moment,
And
this
you could
risk
you could
arises.
conceivably file it at 11:59 p.m. on the 24th, and there would be no way, there would be no way that you could
That
get
would
it.
not be a strategic way to proceed
Right.
in these election law proceedings. As your honors are well aware, these are expedited proceedings. They have to be fully litigated in a matter of weeks, and the board has to quickly respond. Election law
What was
section
the
6.
specific defect
Yeah.
that the Board of Elections found in the papers?
Yes, Your Honor. There were cover sheet defects. There were a number of cover sheet defects.
And you sent it back for
one-
correction,
And sent
right?
it back for correction. When she corrected in the amended cover sheet, the corrected cover sheet, her description of the position she ran for was simply Democratic District 39. And this is facially insufficient to describe the office she sought. The office has to be described on the face of the position.
Didn't
and
it
this
say,
was-
and I'm looking at this in your brief, actually, and it puts it in quote marks, NYC City Council, District 39.
That was on the original cover sheet, and she then amended
Which you
the
found
cover sheet.
defective. Which you
Which,
found,
it was defective for a number of reasons. That was one of the defects, was not a sufficient description. It should have stated that she was running for the office of city council member in District 39, but at any rate, the amended cover sheet,
What other interpretation of that phrasing could there be? New York City Council, District 39 would be the council member in that district, wouldn't it?
yes, Your Honor, if that was in the amended cover sheet, this might be a different situation, but the petition only sought to validate the amended cover sheet, and the amended cover sheet merely had the geographic district without any description of the position sought, and that is facially insufficient and was properly considered a fatal defect by the board. So even if this proceeding were timely convinced, which what quite clearly was not, the petition was properly invalidated by the board.
Thank you.
Thank you very much.
So you have 1 minute for rebuttal.
Okay, there exists no hard deadline in the election law as updated in 2023. If there does exist a deadline, it's May 23rd, as quoted in my brief. Okay, they failed to recognize that the first cover sheet was defective because their own website instructed me to use the wrong cover sheet. So I should be technically given an opportunity to correct that cover sheet again because it meant it would be my actual submission. Okay, the law says instituted, which in a dictionary says get the ball rolling. There's nothing that says completed or service whatsoever in the law as updated in 2023. Okay, I waited to the last minute because I was advised by an attorney poorly to do that. I didn't, okay? Also, when I did file on the 24th, the court website wouldn't give me an index number for days. So how was I supposed to anticipate that also?
Okay, thank you very much.
Can I say one more thing? Okay, service on hand was properly completed and the overnight delivery had no date. So even if I did try to deliver it, it wasn't uploaded at 3:46. I would not have made the post office by 5 p.m. If the court wanted me to serve it overnight, they would have included a date in the blank space. Thank you.
Thank you. Do you wish your minute rebuttal?
Yeah, please. So I just want to quickly, I only have a minute, point out a couple of things about the merits as well. So in one case, as far as the fraud allegations that were in the petition to invalidate are concerned, they weren't pleaded with particularity, which is required. I could cite a couple of cases for you. Naples versus Swiatek, S-W-I-A-T-E-K, 286 AD 2nd, 507. It's a Second Department case. And there's a case from Westchester County Supreme Court that collects cases, matter of Santiago versus Westchester County Board of Elections, 8 miscellaneous 3rd, 1027A, 2005 case. So on its face, the petition fails to state a claim. Also, it fails to state a claim for the non-fraud components of the claim that the petition was invalid because general objections were not filed against that petition within 3 days of the petition being filed as required by statute. And that's a statutory prerequisite to even having a claim to invalidate for the non-fraud claims about, people don't live in the district who signed it and that sort of thing.
Thank you.
Thanks.
Okay, that's it. We're going to call the next case, so.
Thank you.
Stein versus Eisner and Eisner versus Stein.
Good morning, Your Honor. Stanley Schlein for the respondent and the appellant Stein, respectively, in these combined matters. Your Honor, I think the case is synthesized, frankly, perfectly by Ms. Steiner's brief at page 16, when she cites, and I'll just read one sentence with the court's permission, this is not whether the appellant was male or whether there is a confusion as to his gender, but whether the law was followed in notifying the board and the voters of the preferred gender marker pursuant to the current set of rules in both longstanding and recent statutes and interpretation. Your Honor, we recognize that the gender marker was not placed on the petition by Mr. Stein, yet he submitted his printer submitted a correction letter on a timely basis to the board to correct that infirmity. And it stated, it should have been...
This type of error is not necessarily one. Why is this type of error one that could be corrected by a Scrivener's printer statement?
It certainly could be, Your Honor. In fact,
Why could it
was
be?
rejected by the board for one reason and one reason only, as set forth in counsel's letter to the commissioners. It's set forth in that letter by Ms. Patel that, in fact, Mr. Newell was not the printer. That's why the letter was rejected.
Can all errors be corrected by a Scrivener's statement that the Scrivener made an error, or only certain errors be corrected in that manner?
Well, there have been errors of
It's
address,
essential
of spelling of
content.
names, Your Honor, and this is a letter of
Essential
missing of a
content
marker.
that's required in the petition to avoid confusion as to who the person is agreeing to sign the petition for. Is that something that can be remedied by this type of statement by the printer?
I would disagree, Your Honor. I
I'm
believe...
asking a question, so you can't
I'm sorry,
disagree.
then I didn't hear the question correctly.
The question was, is this the type of error that could
Yes, it can be
corrected,
corrected,
where
yes.
it's an essential component to include that information as to the gender?
But the error was suggested to be corrected on a timely basis, and the board singularly rejected it for the failure that they thought was Mr. Newell was not the printer. For no other reason was that letter rejected. And it was set forth clearly on that basis in the council report to the commissioners.
Is he a
Now-
printer?
Pardon?
Is he a printer?
Yes, he is. He printed it on his home printer. He doesn't lose status as a printer because he's also an attorney, of which he was. But he indicated clearly and unequivocally in that letter that he printed the petitions on his home printer. Now, Your Honors, we have cited to the dissent in Mintz, which is the key case that people are referring to in this litigation, by now Chief Judge Wilson.
But it's Again, still a dissent. That's not what the majority said in that case, so.
We
it's a
understand
law
it's,
that
we understand it
required
was a singular
to
dissent,
follow. So
but I
don't we
think
have
it's
to follow what the
instructive.
majority says in Minch rather than what the dissent says?
I think his comments were very instructive and should be,
Doesn't the majority decision in Minch actually support the position of your opposition?
well, it does to the extent that there was an error in the statement of what the office was. The office is now district leader, not district leader male or district leader
It
female.
isn't the way our system set up. The office actually is district leader, either female, male, or non-gendered.
Not
Isn't
any
that
longer, Your
actually
Honor.
The office?
The candidate must list their gender marker F, M, or
A
X.
male district leader couldn't run for the office of female district leader. That's the office. It's a separate office.
It's no longer the title of the office. The office is set forth in 6132 and in the guidances of the Board of Elections' own handbook does not state the office to be anything other than district leader. What is missing, as court correctly indicates, is the gender marker next to the candidate's name. And that was omitted. That was corrected or sought to be corrected on a timely basis.
What about
And one more sentence
What about 21102, which says that the designating petitions and primary ballots shall list candidates for such party positions separately by gender marker?
candidates, Your Honor, the candidates, not the title of the office, which all the string of cases cited by the opposition.
Was the candidate listed by gender marker on these petitions? Was that complied with, in this case, that provision 21102?
It could have been corrected by the board. By the way, as we sit,
Was it complied with in this case?
the gender marker was omitted and pursuant to the rules of the New York County Committee. However, it was corrected on a timely basis. We believe that that letter should have been accepted. And as the court may note, the ballots have yet to be printed. The ballots could conceivably be printed with the
That would
gender
never
marker
correct,
pursuant to the
that would never
correction.
correct the petition. It would only correct the ballot. But let me hear from
Please.
opposing
Thank you,
counsel.
Your
You'll have
Honor.
time for rebuttal.
If it please the court, I'm Sarah Steiner, and I represent O'Malley and Eisner, the respondents in this. Mr. Schlein is correct that the issue here is very simple, and the issue is the fact that there was no gender marker, a material piece of this.
What about his primary argument, which is that it was a Scrivener's error and the Board of Elections should have allowed it to be corrected based on that fact?
I disagree with that. I think that a Scrivener's error or a printer's error is something that can be corrected but is not a material and substantial part of the header, the name, address, and office, which is what's referred to as the header of the petition. You can, for instance, correct the street address if you inverted two of the numbers, or in one case where I had to find one, there were two S's on the end of the word streets. It's not a mechanism for correcting a failure to comply with the law.
Well, let me ask this question, because there, in the Democratic Party rules, there is a designation for M, F, or X, X being non-binary, meaning you don't have to declare a gender, because if that's your preference, that's your preference.
Excuse me, no, it doesn't mean you don't have to declare. That is a declared gender. X equals non-binary and not male or
My
female.
point is that if there is such a category where one can not assign themselves, because that is their preference, to male or female, and the position now is for district leader, what is really the significance of having a designation or M or F? Because you have this other category, which is X, and even according to the rules, it's not necessarily somebody elected to M or F, it's now the top two vote getters. So again, I'm gonna ask you, what is really the significance, like what is the harm here if no one doesn't list that?
Well, the harm is that when you list people on the ballot itself, they are listed with the M, the F, or the X. And if there's nothing, then the voter has no idea who they're voting for when they're told to vote.
They have a name, they have an address, they have the party, the position that they're running for. right? Because they're not voting for M or F because they can vote for X, which is non-binary.
Right, but there has to be an individual with a non-binary gender. This was a fairly major piece of civil rights legislation permitting non-binary individuals to run for a district leader. And it was signed into law about a year and a half ago now. Before that, you had to run for male district leader or female district leader. I know I did explain this in my brief, so I'm not going to go on about it. But the gender marker replaces and is as substantial and material as the former requirement that you declare your gender in the title of the position for which you're running.
Is there a position available for Assembly Member District Leader X, right?
Yes, if it's one of the top 2 vote getters.
Right. So I guess I don't know if we're understanding each other. My point is, if you have this position where someone can be non-binary, meaning they are not assigning, there's clearly an avenue for someone to not have to declare. So if someone doesn't declare M or F, then where is the harm? Because you can also declare
Your
F.
Honor, he's not running as X, and X is also a choice that would have had to have been put in as a gender marker. He's saying, I am male, and he isn't saying that on his petitions. So the Board of Elections and the voters who look at the ballot don't have any way of knowing what the gender of the candidate is on a ballot that otherwise has all other candidates listed by gender when they
Your
are told.
position is it has to say something. It has to say female, male, or X. It can't say nothing.
Correct.
Because if it says any of those 3, then the person signing it understands that they're picking either female, male, or non-binary. But if it says nothing, then they don't know what they're picking.
Exactly, Your Honor. So this is, and the last point I want to make, because I know my time here is limited, is that the council's report of the Board of Election didn't rest everything on the fact that there was a printer's letter from someone who wasn't a printer, which we can argue all we'd like, it doesn't matter that much. The council's report was also based on the fact that this was a material and substantial piece of information that was left off the petition. Thank you very much, Your Honor.
May I just ask one quick question? Is it your position that you couldn't? Is it your position that you can't just call it Scrivener's error and then resubmit?
Well, the time for resubmitting would have passed. And what is it that you would resubmit? The 4 volumes of
with the M.
Well, yes, but the time for petitioning, if he had.
Oh, I see.
That's
You're
gone.
saying because it wasn't on the petitions when they were being signed.
It was never on the petitions when they were being signed. There
Got
was
it,
no
got
way for the voter signing the petitions
So
to
it's
know.
it's misleading the voters. The voters didn't realize, so even if he put the M on, that's not what they signed.
Correct.
Okay.
Thank you, Your Honors.
May it please the court, Susan Paulson again for the Board of Elections. Your Honors, as the courts held in Bosco and then the Court of Appeals affirmed in Mintz, the absence of a gender marker, which was a required descriptor for the party position sought, is not a mere error of form, it's an error of content. It's part of the prescribed content that's required on the designating petition, and therefore its omission is a fatal defect.
Is that why you're arguing that any argument about the Scrivener's error has to fail? Because it's not something that could be corrected just by putting it on after the fact?
Yes, Your Honor, absolutely. And as was just illuminated in the final question to my colleague, the voters had already signed designating petitions, not knowing whether they were necessarily signing a petition for an individual who intended to run for the district leader M position or the district leader F position.
So even if
or
the
district leader X.
ballot was later fixed,
Correct.
they can't go ahead and repetition with the
Correct.
marker.
And this all fits into the scheme of the fact there aren't supposed to be district leaders who are of the same gender.
That's correct, Your Honor. So there are 2 district leaders. The Democratic Party rules state there shall be 2 assembly district leaders of different genders. It could be an M and an X. an F and an X, an M and an F. It cannot be two X's, which is a gender, or two M's or two F's. If the individuals don't know, if the person, no matter what his presentation may be, no matter how he may appear, they don't know his intention to run. He could intend, even if he uses he, him pronouns, could intend to run as District Leader X. And voters need to know, the board needs to know if two individuals were, elected of different genders, and it does cause confusion. For all of these reasons, the plain language of the election law provisions here, 21042, 21102, require that the gender marker be included on the petition. In addition, election law 61321 requires the strict compliance for matters of prescribed content, not a matter of form. For all of these reasons, the board properly determined that the omission of a gender marker on the petition was a fatal defect. And cannot be cured by a Scrivener's letter.
Any other questions? Okay, thank you very much.
Very briefly.
I do have a question for you. I want to go back to Mintz.
Sure.
And, how do we get around that requirement, regarding the gender marker, that it can't be corrected by a Scrivener's error? I mean, how do we get around that?
Certainly. Again, Mintz dealt with the title of the office being district leader male, a state committee member female, or state committee member male. The office is not now identified by gender. That's why we believe Mintz becomes wholly inapt if trying to apply its strict determination to the case at bar. In fact, we now have the title, district leader, period, in a box. The candidate has, and maybe you will find this to be a distinction without a difference, but I don't believe that's the case. Now the candidate has to identify their gender marker. So that is not what Mintz said. There was a different body of law at that moment. The statute was different, and now the rules and regulations of the party are different. And since Section 211.10.2 defers the process to the political party and its rules, nowhere in those party rules does it articulate an enforcement mechanism that the candidate who fails to comply with this provision should be invalidated. And we have that obligation, I believe, in a body of law that said the rules should be no more strict than is necessary for the enforcement of the statute, meaning printing the ballot. And again, as to the questions earlier asked, how do we know how he intended or how Mr. Stein intended to run? I asked the court to scrutinize the record below. There were 27 affidavits by signatories to this designating petition, all of whom articulated Mr. Stein was running as a male, that he identified himself to run in that capacity. It could have been simply cleared up by the acceptance of the letter. Of course, the ballot can be printed now with the designation Todd Stein M. Thank you.
You have 2 minutes.
Your Honors, the affidavits mentioned by my colleague are, of the 25 or so affidavits submitted saying that Stein is male, 16 came from neighbors in his own building. There were many, many hundreds more gotten on the street, as he's proclaimed in his filings, and not all of those people would have had that kind of intimate knowledge.
Is it clear that he petitioned every single person who signed those petitions, or could there have been other people?
According to the papers below, my recollection of them is that he said that he got about 1,800 signatures and he was present for about 1,500 of them.
But even if he was present, they wouldn't know if he's non-binary or male. Just
That's
from his
correct.
appearance. So that doesn't really answer anything.
I agree with that, Your
Because
Honor.
even if you look male, you could still run as non-binary.
Yes, that's absolutely the case. And the people also on the street signing his petitions, it was a single candidate petition, so they wouldn't know that he was running against other people who were male, who were female, who were non-binary. They wouldn't know.
Then it's possible to have a situation with 2 people signing petitions for 2 males.
That's right.
And no one would know that, and how would you challenge that?
That's right. You would not, if somebody had signed his petition and had signed a petition for the other candidate for male district leader, how would you go about challenging those as people who signed a previous petition for the same office? You wouldn't know, they wouldn't know, the court wouldn't know. And if there are no more questions from this court, my time, I don't need any more of it.
Thank you.
Thank you.
All right.